an expectation of privacy. Now again, this came down after the Long case came down, which I just told you about, and before we changed the banner. So there are two issues. Does a military member have a reasonable expectation of privacy in his office space? How many think yes? His door was locked. How many? His office is on the military installation in a military building. How many think yes? How many think no? Okay. And then the second question is, does a military member have a reasonable expectation of privacy in proxy files stored in his computer? Now, this is slightly different because what they claimed is that the proxy files, which are generated automatically by Windows, indicated the types of programs he was using and what times he used them, etc., but that they were generated by the computer, and therefore he would have no expectation of privacy. Now, do you think that's a distinction that the court should recognize? How many think it is? Okay, and how many think it is not? And some people aren't playing anymore. Okay. Okay, so the Air Force Court of Criminal Appeals held that there is no expectation of privacy in the, that there was no expectation of privacy in the log files. So they could seize those because most people wouldn't even know that they're there. And then they said because of that it's distinguishable from long. But it went to the next level of appeal, and at that next court they did something very strange. They said, no, we're not going to make the distinction between log files and other, because at the oral argument for this case, the investigators admitted they didn't just seize log files, they seized other files from his computer anyway. But they said, no, he still had no expectation of privacy. And now let's look at their rationale. First, they said the banner put him on notice. He says, wait a minute, Long case, you said the banner wasn't good enough. They said, oh, no, it's fine. Then they said, well, you didn't even testify as to what your subjective expectation of privacy was, because you're supposed to say, well, I thought it was private. Well, it turns out Long didn't either. She never testified in her case. So he's like, well, wait a minute. Then he says, well, I was issued a password. That worked for Long. And they said, oh, no, passwords are not significant. And then finally, what seemed to turn it was the commander said, well, I could have accessed his computer and seen everything on there anyway, so how could he have had an expectation of privacy? Now, interestingly, this was incorrect because the individual actually had an encryption key, a special CAC card, common access card, which encrypts his files. And so although the commander could have got on the computer, he could not have gotten into any of his files. So strangely enough, the only thing that really was the difference between Long seems to be erroneously reported. So this is kind of a strange case. Okay, so the next case we have is actually a commercial case, Quan versus Arch Wireless. And this actually involved a police department. The police department had an email policy that says everyone should realize that there's no expectation of privacy when you send emails as part of your official police duties. And subsequently, they got these little text machines. Now, hardly anyone uses those because we have far more sophisticated PDAs now. But they had little devices. They could just send text messages. That's all they could do. And so they purchased these text message devices for the police force. And they purchased a contract which would allow them to send up to 25,000 characters per month. Well, it turns out a lot of the policemen were sending a lot more than 25,000 characters. And so the individual who was responsible for collecting the money to pay for this, he said, look, if you do go over 25,000, you're either going to have to pay that overage because we didn't pay for it as a police department, or you're going to have to explain to me why you're going over, and you're going to have to show me all your emails. And he says, but if you don't, if you're just willing to pay, I won't look further. So Quan just paid every month. He paid quite a bit. And then finally, a lot of other people were paying. So the chief of police says, wait a minute, this isn't fair. If they're doing official police duty, they should not have to pay extra just because they send a lot more characters. So I want everyone's log files to be reviewed to see what text they're sending. And if it's really all a government official, police business official, then I'm going to up the limit. Well, when they did this, they found out that Quan had a bunch of personal sexual messages in his thing. And so they took action against him. And he says, whoa, wait a minute, I had an expectation of privacy. Because they told me as long as I paid, they wouldn't check my emails. Now, the government says, well, no, it was clear in the policy that anyone who sent these types of text messages had none. So how many of you think that he does have an expectation of privacy? How many think he does not? Okay, it's pretty evenly split here. What they ruled is that he does not. That he does, I'm sorry, that he does. They said even though the policy said that he does not, the fact that someone implemented it in a way that gave it back is significant. Now, the problem with this case is that it puts every agency or corporation into a bind. Because as you know, we changed our whole banner. We did all this training and everything else in the Department of Defense to make sure we had a good banner. But what this case seems to say is that some really low-level person somewhere in the chain of command could say, well, don't worry. In my unit, I'm never going to check any of your email. And he could effectively trump our policy, even though he has no authority to change it. Because this court says that if they do by action something contrary to their policy, that can effectively change it. Now, the other issue that got raised is, does the chief's intent matter? And the lower court said, well, yes, it does. Because since he was just trying to do a good thing, he was trying to save people money, then that's a significant thing, and so then it doesn't become a problem. But the higher court said, no, it doesn't matter at all. Regardless of what his intent was, if the lower level employee effectively changed the policy, that's effective. Okay, now here's an interesting case. An individual views child porn on the internet while he's on a business trip. Then he goes to Canada. Well, when he arrives in Canada, they check his record and they see that he has some minor convictions in his past. And they're related to sex, so they ask to search his computer. They search his computer and they find this child porn on there. And they ask him about it and he says, well, I didn't download any child porn. I just looked at it. I never saved it. Because he says, I wanted to make sure I didn't get in trouble with the law that says you're not allowed to save child porn. I just looked at it. Now, of course, when you look at it on the computer, it saves an image in your cache. That's how the computer can display it to you. So even though he didn't save it, apparently he didn't realize an image was still saved on his computer. So they said, okay, you're not coming into Canada. So they called U.S. Border Patrol and said, hey, we're sending him back to you because we're not letting him into Canada. We're going to fly him to the Seattle Border Inspection Station tomorrow, or Seattle Airport, actually, and you guys take care of him, whatever you want to do. So when he arrives in Seattle, they seize his computer, and they search it, and they find these same images. They prosecute him. There's two issues here. One, is the search legal? The customs agents who seized the computer never got a search warrant, or search authorization, or anything else. They just started looking through. So how many think that is a legal search? How many think it's an illegal search? Okay. And then the second issue, well, let's just do that one first because that's a big one. The court held it was legal, and they said under the border exception to the Fourth Amendment. In other words, when you're near the border, the government has a lot more authority to search without a warrant. Now, how far does that border go? Is Seattle on the border? No. So why did they get to do it in Seattle? What's the issue there? Okay, right. Could I do it in Indianapolis? Could I say that I'm going to do a border search in Indianapolis? Yeah. Yes. Why? Right. And as long as you came in on an international flight and this was your first stopping point, it's also your border. Okay? So the court held in this case it was a border search, even though it did not occur at the border. It did occur at an international airport, which was his first stop in this country. So therefore, no search authorization necessary. Question?
I'm just wondering whether he could have made the case, since he hadn't been admitted to Canada, that he hadn't left the U.S.
Yeah, the unfortunate thing is physically he had. So he did. He theoretically didn't cross the border in a way because they rejected him, but in fact, physically he did, and he had to report back. So that's an interesting question. Okay, the second question is the possession of the child porn in cache enough to constitute the crime of possessing? And in this case, the court said yes. They said, now it appears that he was not smart enough to actually get to it, but the court did say that there are experts who indicated that because it's in cache, if he was sophisticated enough and, you know, if he tried to get to those files, Windows would send some messages saying, you know, you really shouldn't go here, you shouldn't. But as long as he said, okay, 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 he could get there and he could change the names and save them as his own files, and therefore he possessed them. Now, I say compare with the Kaczynski case, which is a Ninth Circuit case. In that case, a guy had 19,000 child porn images on his computer, and they said they could not be used because, in sentencing, because of advanced downloading, lack of sophistication, etc. As you know, if you use some of these browser accelerators, they'll actually download files on the page that you're on, even though you haven't asked it to download them, just so that if you click on that, it'll already be pre-downloaded. So in theory, you could have images in your cache that you never knew about, that you never even wanted. So one of the courts said that was significant. This particular court said no. It may have been the fact that he actually admitted that he did go to these sites and looked at them, so that would be kind of a significant issue. Okay, so here's another border case. Comes on the heels of the prior one. Arnold flew 24